Hello everyone and welcome to Synergy Consulting Knowledge Series. I'm CA Praveen Agrawal. Today we talk about a very important turning point in real estate insolvency. A situation where one real estate company may have multiple projects, each at a different stage of completion, with different home buyers and separate funding streams. Now the question is, if one project fails, should the entire company be pushed into insolvency? Or should each project be resolved separately? The Supreme Court of India has answered this issue in the year 2025 judgment. The title of the judgment was Mansi Brar Fernandes versus Shubha Sharma and Others. This matter reached to the Supreme Court when certain persons who had invested in real estate units under agreements promising buyback and assured returns filed an insolvency petition under Section 7 of the IBC. The key issue before the Supreme Court was not only whether insolvency can be triggered, but more importantly, how real estate insolvency should be conducted when a company has multiple independent projects. And this is where the judgment became a landmark. The Supreme Court laid down two fundamental principles in this regard. First principle was a person who invests for assured returns, buyback, or profit is a speculative investor and not a genuine home buyer. Such investors cannot use the IBC as a recovery tool and cannot trigger Section 7 insolvency proceedings. Second, insolvency in real estate must, as far as possible, be conducted on a project-specific basis and not automatically at the entire company level. The court explained why this approach is necessary because every real estate project has separate land, separate approvals, separate RERA registration, separate buyers, separate funding, and sometimes even separate escrow accounts. So if one project is in distress, it should not destroy other projects that are viable and near delivery. IBC is a resolution mechanism, not a punishment mechanism. Especially in real estate, insolvency must aim to complete homes, not collapse companies. The Supreme Court also made it clear that FERA cannot be ignored during insolvency. While IBC deals with corporate insolvency, RERA protects home buyers and regulates project delivery. Therefore, both frameworks must work in coordination, not in conflict. Adjudicating authorities must examine RERA filings, project timelines, escrow fund structures, construction status, and buyer interest before pushing a company into blanket CIRP. So, what does this judgment mean for professionals and stakeholders? You see, IBC cannot be used for recovery by investors seeking profit or exit. Genuine home buyers must be protected. Real estate insolvency must prioritize project completion. Resolution must be project-wise, not company-wide, wherever feasible. RERA and IBC must function in alignment, not opposition. I hope this explanation provides clarity on this landmark judgment. We will continue to decode more developments in insolvency, real estate, and regulatory law. This is CA Praveen Agrawal signing off. Thank you so much. Thank you.